Patriot Act was created in response to the events of September 11, 2001, with the goal of giving our government the tools it needs to protect us from any future attacks. In the 3.5 years since its passage, the bill has been surrounded by controversy, coming under attack by various civil liberties groups. Some of the provisions of the Act are coming to their sunset period, essentially a reevaluation, and the Senate and the House will have to decide which portions to keep and which to let go. Our goal tonight is to address the issues and concerns raised by the Patriot Act, and we have two, as one of my classmates described them, staggeringly qualified speakers to debate these issues. Since I'm not one of them, I'm going to bring up our introducers of these speakers, Alex Dewar, who is president of our Student Government Association, and Katie Wheeland, who is the president of the Wheaton College Conservatives.
You can go right ahead, darling.
All right. I first want to thank Isaac so much for doing a lot of the work to put this together. He's been running back and forth trying to get SGA funding, and I know too many times that can be too difficult. But anyway, thank you again for your work. Barney Frank is a member of the United States House of Representatives and as a Democrat has represented the 4th District of Massachusetts since 1981. Congressman Frank was educated at Harvard College, graduating in 1962. Afterwards, he taught undergraduates at Harvard while studying for his Ph.D. and left in 1968 to become chief assistant to Mayor Kevin White of Boston, a position he held for 3 years. He then served 1 year as the administrative assistant to Congressman Michael J. Harrington. In 1972, Congressman Frank was elected to the Massachusetts legislature, where he served for 8 years. During that time, he entered Harvard Law School and graduated magna cum laude in 1977. In 1979, he became a member of the Massachusetts Bar before being elected to Congress in 1980. While in state and local government, Frank taught part-time at the University of Massachusetts Boston, the John F. Kennedy School of Government at Harvard, and at Boston University. He published numerous articles on politics and public affairs, and in 1992, he published Speaking Frankly, an essay on the role of the Democratic Party in the 1990s, which I actually have picked up a copy of, even though at that point, in 1992, I don't think I was educated enough to read that then. Frank is the ranking Democrat on the Financial Services Committee and is also a member of the Select Committee on Homeland Security, where he serves on the Subcommittee on Infrastructure and Border Security and on the Subcommittee on Intelligence and Counterterrorism. Additionally, Barney Frank also holds an honorary degree from Wheaton College, and while Norton has been drawn in and out of his district over the years, he's always represented Norton well. Above all, personally, I'd like to say I hold Congressman Frank as a political idol and for all his work he's done on progressive causes over the years. Please join me in welcoming Congressman Barney Frank.
Good evening, ladies and gentlemen, and again, I'd like to welcome you to this evening's festivities, and I have the distinct pleasure of introducing Mr. Viet Dinh. Vietnamese refugee, Mr. Dinh graduated magna cum laude from both Harvard College and Harvard Law School, after which he clerked for both Judge Lawrence Silverman of the U.S. Court of Appeals for the D.C. Circuit, as well as for Supreme Court Justice Sandra Day O'Connor. In 2001, Mr. Dinh began his services as the U.S. Assistant Attorney General for Legal Policy, where he worked to eliminate racial profiling in federal law enforcement to protect children from exploitation, as well as to combat human trafficking, among his many endeavors. After the tragedies of September 11th, Dinh found himself immersed in the review and revision of the Department of Justice's priorities in terms of its policies and practices toward terrorist acts. At that time, Mr. Dinh also played a highly influential role in the creation and development of the United States Patriot Act, as well as in the reconfiguration of the Attorney General's guidelines, which governs both the federal law enforcement activities as well as the national security investigations. Currently, Mr. Dinh is a professor of law and co-director of Asian Law and Policy Studies at the Georgetown University Law Center. Mr. Dinh's publications include Defending Liberty, Terrorism and Human Rights, as well as Financial Sector Reform and Economic Development in Vietnam, just to name a few. And without further ado, I give you the renowned Viet Dinh and Mr. Barney Frank.
Sorry, I just wanted to say the format of tonight's event is going to be 4-minute opening speeches from each of Professor Dinh and Congressman Frank, followed by we have 8 prepared questions. Afterwards, there will be opportunities for audience Q&A, at which point the floor will open up to the audience. So thank you all for coming and enjoy.
Beauty before youth. You go first.
That is a lawyer's way of appearing to make a concession, which is, of course, an advantage. So you understand what we will be dealing with. But I'll go last. That means at the end. The events of September 11th clearly required us to change our law enforcement model. We had, until then, the basic law enforcement model of deterrence, appropriate to a free society. Basically, under that model, the bad guys get first shot. That is, we did not have in place emphasis on prevention. The notion of deterrence is that if people do bad things, you have a very high chance, you hope, of catching them and punishing them, and they are deterred from doing bad things. And that worked reasonably well. It's not the entire system. And then on September 11th, 19 vicious killers killed themselves so they could kill thousands of other people. And deterrence doesn't work with people prepared to kill themselves. So there was, without question, a need for us to add to our law enforcement arsenal, and particularly to deal with the problems of people who cannot be deterred. Now, what you then do is to get into prevention, and you prevent in 2 ways. First of all, you physically prevent. We mostly do that when you get on an airplane. Our efforts in the airports are to physically minimize the chances that someone will be able to do something terrible on that airplane and then with that airplane. But you also prevent by trying to intercept people, by trying to get them before they do bad things, by knowing who they are. And that requires a degree of intrusiveness, and that's without question. And one of the things we ought to establish at the outset, I served at the time on the House Judiciary Committee. And the House Judiciary Committee rejected, and I respect the Republican chairman at the time, rejected John Ashcroft's effort to get us to pass the bill basically without any questioning in a very short period of time. And we had hearings, and we had a very good deliberative process in the House Judiciary Committee. This isn't widely known. The House Judiciary Committee then passed a bill unanimously to enhance law enforcement, to give people in law enforcement more power, to give them full powers with new electronics. Our wiretapping statute had been passed in 1968, before cell phones, before the Internet. So it had to be upgraded. And here's a part of this that is very troubling to me, and it's the process by which we defended democracy, because it was an outrageously arbitrary and undemocratic way to do it. After the House Judiciary Committee passed a bill that passed unanimously out of committee that had a lot in common with the current Patriot Act, but had some important differences, represented some genuine compromises, because the Attorney General didn't like it. He got the House leadership literally to discard the bill that had been the process of committee deliberation, and instead a bill written in secret, not with an open process, came to the floor of the House and with no debate allowed by the Republican leadership was passed. It really is a striking irony that we defended democracy in such an undemocratic fashion. Indeed, I will tell you that I have said from time to time in the floor of the House, and this is one of the examples, although it was not yet then relevant, we are encouraging in Iraq a form of democracy, and particularly in which the Shiite majority will not ignore the Sunni minority. And from time to time, I feel compelled, when I'm speaking on the floor of the House and the Republicans are doing similar things, to say to the Iraqi people who might be watching, please do not try this at home, because we are trying to encourage them to be democratic. But the major difference between the 2 bills, the one that I voted for that was simply discarded and the one that passed, and there'll be more that we'll talk about, but it has to do with whether or not you believe in my judgment that law enforcement is close to infallible. Because the major difference between the 2 bills is that in the bill that we had, there were more requirements that the law enforcement agencies get some kind of judicial approval of what they do. And I do not understand how people, certainly who've lived here and have seen the outrageously abusive behavior of the FBI in Boston in the mafia investigations, in which innocent men were framed by the FBI, who looked at Wen Ho Lee under the Clinton administration, falsely accused, apparently, of nuclear espionage and locked up and shackled for a year. A chaplain down in Guantanamo whose lives was ruined because he was falsely accused of espionage. A man in Oregon because the FBI misread the fingerprints from the Spanish government. This is the major difference. I am prepared to give law enforcement more powers for the reasons I said, but the notion that we should give them essentially unrestrained rights here without the courts supervising is a very great error. And it is not just the Patriot Act alone. You have to look in context. We have a president who has announced and was defended by the Justice Department in that announcement that he has the right, because we are now at war, to lock up anybody, anytime, for as long as he wants without justifying it to anybody, including American citizens. And by the way, we are in a war that's probably going to last for a very long time. So, fortunately, the Supreme Court overruled that. But that's the issue. The issue is not, in my judgment, whether we give law enforcement adequate powers, because I agree that we should have. The issue, to me, is do you allow the President of the United States, the Attorney General, and law enforcement unchecked power? Should they be able, on their own say-so, to imprison people indefinitely for the rest of their lives without ever having to justify it? Or should we try and give them more power but preserve some requirement that they get permission in some cases and that there be an appeal from their error in other cases? And I'll close with that. Even in cases where there may not be time for them to get permission, I acknowledge there will be some, I see no justification whatsoever for refusing procedures whereby people imprisoned, people whose assets have been taken away, but particularly people who have been imprisoned, are denied access to the courts. And I think the notion that somehow the American judicial system is incapable of allowing us to protect ourselves and therefore must be totally bypassed in some of these areas is fortunately untrue.
Thank you very much, Congressman Frank. It is a great pleasure to be here with you all. Thank you for the great attendance for Congressman Frank. I would not be arrogant enough to assume that you all turned out to hear me, so I would just simply play here as the show for Congressman Frank's wonderful words. I do mean it is an extraordinary honor for me to be here to share with this conversation with Congressman Frank. He contributed significantly to the deliberations of the USA Patriot Act. If you look at the current version, Section 223 of which, we still call it the Barney Frank Amendment, which was a very important addition to the law, which allows for people who are aggrieved by the misdeeds of law enforcement in surveillance areas to actually have a cause of action in order to sue for such aggrievement. I think that is an important safeguard. It is not, it should not, and is not the only and exclusive safeguard. And in many ways, I think, as we engage in this national conversation, whether or not we reenact some or portions of the USA Patriot Act, we should think about more creatively, like Congressman Frank did during that time, to think about those safeguards, perhaps even strengthening Section 223 in order to include greater civil sanctions and perhaps even criminal sanctions for the deliberate, willful violation of rights of the law-abiding American citizens. First, a word about the process. Congressman Frank is absolutely correct that the bill that was passed out of the House Judiciary Committee was not the bill that went to the floor of the House in final passage. The bill that went to the floor of the House was actually the Senate bill. At the time, if you can appreciate, we were trying to do this in both houses. And the Senate bill was negotiated by Chairman Patrick Leahy, Democrat of Vermont, and Senate Majority Leader Tom Daschle at the time. In the final analysis, the House and Senate leaderships had to decide which version of the bill would be the one that was passed by Congress, because if you recall, Article 1, Section 7 of the Constitution requires an identical bill to be passed by both houses to be presented to the President for his signature or veto. And the collective decision of the House and Senate leadership was to go with the democratically negotiated Senate bill, and so therefore the bill was substituted for the House House version. We tried to keep as much of the substance of the House bill as possible without sacrificing the substance of the Senate bill. That's why you saw the final vote was 98-1 in the Senate, reflecting its derivation from the Senate side, and a vote of approximately 6-1 in the House, reflecting I think the genuinely felt and legitimately felt the dismay that some House members, including especially its Judiciary Committee members, regarding that process. But I do not think it was in any way undemocratic, but rather a reality of the congressional process that we resulted in the bill that we did. Had we gone with the House bill, we would probably have the exact same reflection of the vote on the Senate side, simply because of the nature of the bicameral system of our government. I do take very seriously Congressman Frank's point regarding prevention. After 9/11, we know that we cannot simply react to crimes that happened before, because 9/11 was a catastrophic threat to our national security. 19 persons with a couple of $100,000 inflicted the most catastrophic loss of human life in this country outside the Civil War. We simply cannot wait for the crime to happen and then pick up the pieces, investigate, and count the bodies. Here we know the 19 persons have already paid the highest price that man can inflict upon another man. And so our task is to prevent another catastrophic attack from happening. There are only two ways for you to do prevention. One is detention, the other one is information. Detention is out of bounds unless we are going to repeat the mistakes of our history, the mistakes that resulted in the Palmer raids, resulted in the mass internment of Japanese and German Americans during World War II. So that left us with information. In this regard, we are actually much more constrained than our French and Italian counterparts, which have a tradition of preventing detention in their laws. Instead, we seek to discover information about terrorist threats before they happen. And we tried, and I think we succeeded, in making sure that we update the laws of the technology to make sure that the law does not govern from Title III of 1968, but rather the USA Patriot Act of October 26, 2001. What was assiduously careful in that process is that even as we extended the law to new technologies, we kept the same level of judicial supervision and authorization that pre-existed in the analog world. That may not be enough for some of us. That may well be a calibration that we need to revisit when Congress takes up this debate before. But I think that it is fundamentally incorrect to insist that we have taken the judiciary out of the process. They are the first stop, and in many cases, the last bulwark of our liberty. Thank you very much.
And at this point, I'm going to ask our question askers to come up, the two distinguished students, Leslie Dean and Alex Asanchev.
I'd just like to thank again our two guests for joining us for this debate tonight. And firstly, I'd like to pose a general rhetorical question around which this debate will be framed. And that question is, the threat of international terrorism is a reality we face, and we certainly want the government to be able to thwart potential terrorists. Does the Patriot Act appropriately and adequately address the threat posed by international terrorists? And now we'll move on to questions. And now I'd like to move on to questions addressed first to Professor Dinh, who will have 3 minutes, and then Congressman Frank will have 3 minutes to respond, and then a 1-minute rebuttal. Professor Dinh, the Bush administration has repeatedly described the war on terror as presenting a fundamentally new challenge to our security and global peace. Do you agree, and if so, how is this different from other security threats we have faced in the past?
I largely agree with that because we saw, if you recall from high school civics or first year of political science, the world that we live in right now, the sovereignty-based world of international order, was created after the 30 Years' War in the 1600s, and from that, the Peace of Westphalia. That divided the world roughly into 191 member nations, 193 if you count the Vatican and Taiwan. Those 191 members played like kids in a playground, generally hurting each other, but but never killing each other, because there is restraint to sovereignty. At the end of the day, you have to defend the population. You have to protect your borders, and if you don't, you get outside the bounds of those civilized conduct. There is retaliation against your sovereignty, against your nation. The example of Muammar Gaddafi finding Jesus recently, I think, is a perfect example of how even the most rogue nations of the most outrageous dictator can find a way in order to cooperate in a civilized world. Compare that to the world of international terrorism, where the international terrorist does not have a territory to defend, but simply an ideology to protect. And couple that with the weapons of mass destruction that are quite crude at times, but have the ability to inflict warlike damage on established polity. And what you have therefore is force unrestrained by territory, unchecked by responsibility, unhampered by sovereignty, by the obligation and responsibilities of sovereignty. And so I think we face a catastrophic threat that does not admit of traditional warlike engagement in international relations, but rather brings the coordination between intelligence, military, and law enforcement together to make sure that we meet this pervasive and asymmetric threat. I will end only by explaining why I think the threat of terrorism is pervasive and asymmetric, simply by recounting the statement of a terrorist group in 1982 when it sought unsuccessfully to assassinate then Prime Minister Margaret Thatcher at the Conservative Party conference in Great Britain. That afternoon, the terrorist group released a simple statement that is chilling in its simplicity. It said, "Today, we were unlucky, but remember, we only have to get lucky once, and you have to get lucky always." That is the pervasive nature of the threat. Each and every single one of us is a target of opportunity. All that we can do is aid the hand of fate in order to reduce the risk of terrorism to strike on our soil. And thank God, with the tools that Congress gave us in the USA Patriot Act, we can claim the moderate success in the last 3 years of not another American life having been lost to terrorism on American soil.
Well, I must say I was thrown a little off stride by the image of someone getting lucky with Margaret Thatcher, but I'm going to try and overcome that and being as it was in the IRA. I would take a little bit of issue with the history. Professor Dinh describes this previous, more civilized thing. I don't think Hitler cared much for sovereignty or was restrained by it. And there's some relevance to that, because obviously the mass murders of September 11th were terrible. But the threat of thermonuclear war was also pretty terrible. And, of course, the Nazi attack and the Japanese attack on Pearl Harbor were terrible. And I do think, in fact, there was a point, certainly in World War II, when our security as a nation in the future was much more in jeopardy than now. I want to do everything we can to prevent these murders from doing this again. But I don't think it is historically accurate to say that there was something uniquely terrible about this threat compared to what we faced with Hitler and Japan. I don't think it was foreordained we were going to win, or the possibility of thermonuclear war. I do agree, as I said, that we need to have better law enforcement, but I disagree with the notion that there's nothing in the Patriot Act that enhances executive law enforcement authority and diminishes somewhat the judiciary. For example, the right to get records from libraries and educational institutions. The level of judicial supervision, I believe, has been diminished there. Not wiped out altogether, but pretty substantially diminished. And again, I think this does come down to whether or not you have complete trust in the infallibility of law enforcement. But there is clearly a lower barrier for them to be able to get records. And we have history of the law enforcement people not doing what they ought to be doing. I also think that you can't look at the Patriot Act in isolation. I agree that detention is not the method. But the President of the United States insisted until the Supreme Court overruled him that he had the right for indefinite, unlimited, unjustified to anyone detention of American citizens. Those were the issues in the Hamdi case and in the case of Padilla. They arrested 2 American citizens and locked them up and said, we're going to lock them up for as long as we want, and it's none of anybody's business. And again, this is part of the atmosphere there, because one of the things I would like to do, one of the issues we have here is there this right to lock people up without anything? By the way, one danger, and I want to be critical of Congress, there is a law in the books that says you can't lock up an American citizen except in pursuance of a statute. And sadly, 4 justices of the Supreme Court The Supreme Court was 8-1 on that. Clarence Thomas was as useful in defense of the Constitution on this issue as he is on most others. The other 8 said, no, this is not the right thing to do. But 4 of the justices did say, yes, we agree that there has to be a statute to lock people up. Sadly, they found it in the resolution that I voted for that authorized us to attack Afghanistan after September 11th. And they said the language that said we could do anything necessary meant you could lock people up. I think that's a terrible mistake. So the fact is that this administration has been asserting its right to indefinitely detain even American citizens without having to justify that to anybody. They say only for as long as the war's on. The war may be on for the rest of our lives, and I think that's a serious problem. So I do believe that there has been in several places in the Patriot Act a diminution of the extent to which there can be outside checking on this. And they've also argued in some cases when they lock people up, not only do they not need permission beforehand, but you can't go to court afterwards. You cannot go to court afterwards to get yourself let out. Now, the Supreme Court fortunately didn't buy into that. The administration is still resisting that. So the question of detention is still before us, and it is. And then the other piece is, as I said, is I think with regard to getting records and other things, there has been a reduction of what you need to do in terms of going to courts. And I think we are in greater danger of arbitrary law enforcement, rogue law enforcement people making mistakes in law enforcement, people being unfair, than we are of the courts interfering with legitimate law enforcement needs.
I will stick to my brief with the USA Patriot Act. My reservations, public reservations regarding the detention policy and military matters have been published elsewhere, so I'll stick it to here. Suffice it to say that matters of detention and military operations were blissfully well above my pay grade while I was in government. With respect to the USA Patriot Act, Congressman Frank brings up a very good point with respect to Section 215, the so-called library records provision. But unfortunately, there's been much great misunderstanding about this provision and what it did to change prior law. I, as a federal prosecutor, any federal prosecutor could go into court and get a grand jury subpoena for business records, including the records of library and bookstores prior to USA Patriot Act. Ken Starr did this with the Kramer's Books and Afterwards in order to get the records of Walt Whitman's Leave of Grass. Law enforcement did this in order to solve the Unabomber case by looking at library records of books that were cited in the manifesto. And that grand jury subpoena is issued by the clerk of the court as a rubber stamp rather than approved by a federal judge. Congress simply gave the same power to national security investigators, but because it is a matter of national security investigations, it is done in secret. It is done confidentially. There's a cost to that. That's why Congress placed specific safeguards in there, and we have Senator Leahy to thank for these safeguards. They include, one, they have to be personally approved by a judge, not simply rubber stamped by a clerk of the court. Two, it has to be reported to Congress every 6 months how this provision is used and fully in the manner in which it was used. And then thirdly, it cannot be used to target First Amendment activities. It is perhaps a broader debate whether or not we should have such a restriction on criminal process generally, including grand jury subpoenas, so that we limit the use of such coercive authority to not institutions or activities not involving the First Amendment. But that is a debate that is broader than and independent of Section 215 of the USA Patriot Act.
All right. The next question is addressed to Congressman Frank. In any democratic society, one major goal is to strike a balance between security and freedom. The threat of terrorist attacks forces us to decide how to recalibrate that balance. Doesn't the Patriot Act merely respond to our new circumstances, and isn't it prudent to emphasize security over privacy in times of war?
It's not necessary in many cases, and I will go back to this library issue. In fact, I do not read the Patriot Act as giving the judge the power to disapprove that request. There's a that is not an interpretation that I believe the law upholds. I think they pretty much can do whatever they want. And it's true, they could go to a grand jury. You said, well, the difference is secrecy. Yeah, it is true Kenneth Starr went and got Monica Lewinsky's book records, and because it couldn't be secret, enough hell was raised, so he was deterred from doing that. I think you underestimate the value of public debate in preventing abuses of our civil liberties. And having it be transferred from a public process to a secret one, I think makes a very big difference. I think, in fact, knowing that your records were subpoenaed It's not fun to have them subpoenaed, but at least knowing that gives you a kind of ability to defend yourself that you don't now have, because these things are done by the FBI in secret. And I would say this is an example of where we do not have to sacrifice privacy to protect security. I think this example of a relatively unrestricted, because the judge has no real discretion in this, as I understand it, a relatively unrestricted jurisdiction by law enforcement to get your records. And it says in the law they shouldn't do this for First Amendment purposes. Well, how the hell do you enforce that? If they can do it whatever they want, they can do it. Now, things have gotten better. And let me just, I do want to say this. I don't want to be alarmist here. And I agree with Professor Dim when he talks about we don't have the Palmer raids, which we had under that great liberal Democrat Woodrow Wilson. And we didn't have the internment of Japanese Americans that we had under our great liberal Democrat Franklin Roosevelt. Then we didn't have the McCarthyite period. I do think, and I have been pleasantly surprised by this, there have been fewer actual violations of American civil liberties in the post-September 11th period than in most previous crises in America. Things were worse during World War II and World War I, and when they tried to ban the teaching of German, and did ban the teaching of German in some places. And so it wasn't that bad. But I still do not see any reason why they have to be able to do this in secret, and that is an example. There's another problem that I have with this administration, and there are a lot of ways to protect yourself. Prevention doesn't simply mean getting information from people. That's a part of it. But prevention also means having law enforcement and other people out there. And part of the problem we have is an administration which is so determined to cut taxes that those people whom we use to protect us aren't there as much as they should be. One of the ways you protect yourself is by more police and by more fire and by more law enforcement personnel, and they've been going the other way. And to some extent, I think that there's, in some people's minds, a trade-off between increasing what I think is arbitrary authority of law enforcement and having fewer people. And that is part of the problem. So, yes, finally, yes, there is some diminution in privacy. You should understand, if you ever thought differently, your email is not terribly private. With regard to your email, let me quote what I learned at Boston City Hall in 1968 from City Councilor Freddie Langone. You never write when you can talk, you never talk when you can nod, and you never nod when you can wink. And if you think that your email is private, it isn't. And yeah, there has to be some of that. But I will also go back. The ability, what troubles me is not the ability to get this information, but the ability of law enforcement to get it without restraint. And finally, I would just say, and Professor Dinh said, well, he differs with the administration, he said, on detention, et cetera. But that's part of the problem, because my problem with the Patriot Act is not just what's in it, but what isn't in it. And we're going to take up the Patriot Act again because, by the way, one of the things that we did get is we insisted, it wasn't exactly the Senate bill. If it was, we wouldn't have had any sunset. It was the House that insisted on a sunset. The Senate went along with the administration and wanted no sunset at all. That would have been there ad infinitum. Fortunately, because we insisted, we do get to do this again. And the Patriot Act is not just a problem because of what it says, but because of what it doesn't say. And I hope we will address this outrageous notion that the President of the United States can lock up anybody, anywhere, anytime. That ought to be in the Patriot Act, namely a constraint on that.
I agree with Congressman Frank that governance and certainly counterterrorism is not a static process, but a dynamic one. We should always be thinking about the tools that we need in order to protect America's safety and the liberty of her people, while at the same time knowing that any tools that we give has the potential for misuse and abuse, and institute safeguards correspondingly in order to check against this misuse and abuse. And I thank the Congressman for acknowledging that such misuse and abuse have been far in between in this regard. I would just like to read a quick quote from Democratic Senator Dianne Feinstein of California, who in October 21st, 2003, in a hearing, she said, quote, "I have never had a single abuse of the Patriot Act reported to me. My staff emailed the ACLU and asked them for instances of actual abuses. They emailed back and said they had none." So I think that there have been a lot of overblown fears, but fears that are, while genuine, may not be well-founded. I think it is not a fault of the populace. I think that is an advantage of democracy, whereby we zealously guard our liberty against government. But as we engage in the policy debate, I think it behooves us to separate the heat from the light, the smoke from the fire. And I think that we go a long way through conversations like this one. With respect to your core question regarding liberty and security, I will give you $1 for every single time that somebody quoted Benjamin Franklin to me, and by the time I'm done, you'll be Rupert Murdoch. You know, that famous quote that they who give up essential liberty for a little temporary safety deserves neither. I completely agree with that. You should not give up any liberty, let alone essential liberty for safety, let alone temporary safety. The end of government in democratic society simply cannot be security. Security is only the means through which we secure our core concepts of equality, opportunity, and at the base of it, liberty. But we cannot have liberty without that security. And so in this regard, I think liberty and security are symbiotic, have a symbiotic relationship. They're complementary goods, kind of like that old Sinatra song, love and marriage, horse and carriage. You can't have one without the other. And I think it behooves us in this. I still have the optimism of newlywed. I just got married this last year, so indulge me, Congressman. But I know, a sap to the audience, I am sorry. But I do think that as we go forward, that we do need to look at what we need to safeguard. I think I read Section 215 differently. It does give, I think I read it to give the judge the power to deny the application if it does not meet the requirements of the provision. But to the extent that there is any ambiguity, I think that that is one of the areas that Congress can revisit and dot the I and cross the T. I would greatly draft a clearer version to make clear that the judge has the authority, indeed the responsibility, to deny a Section 215 order if it does not meet requirements of the substantive requirements of that Congress insisted in that provision.
Thank you. I do have to remind you, Professor, that the administration you serve believes that for at least some of us, love and marriage definitely are not allowed to go together, and I do regret that. And I accept that latter offer, but that is one of the problems. If, in fact, the judge was free to reject those applications, the way it is worded and the way it was intended, the judge was simply supposed to be the kind of recorder of those things. And that's one of the changes I want to see. I also agree, as I said, I volunteered. I don't think there have been many abuses. We did have one case. It wasn't directly under the Patriot Act. It was in South Carolina where a man was being prosecuted by the United States government by that great distinguished jurist and U.S. Attorney Strom Thurmond Jr., who was appointed at the age of 29, and because he was carrying a sign that was anti-Bush in a place where people were allowed to carry signs that were pro. I worry about it, but I do agree that we have not seen major we have done much better in civil liberties, but I take partial credit for that. And one of the big fights we had over this was the sunset. Now, the bill that we passed out of the House had a 2-year sunset, or out of our committee. The Senate bill, it was not exactly the Senate bill, and I do disagree with you that it was simply a matter of convenience to take the Senate bill. They didn't allow any debate in the House. But the Senate bill had no sunset. And I genuinely believe, had we not succeeded in getting a sunset, well, let me put it this way. I am much less confident that we would have seen no abuses if it wasn't for the sunset. Sunset has a purpose. We weren't able to get judicial approval, but we were able to get the FBI on a leash. And one of the things I will insist on when we renew this is that we keep the sunset in there, because I am afraid of what would happen if we didn't have that. So I agree there haven't been abuses yet. I think that's partly because of the complaints we have been raising and because of the sunset. And I would just say again, yeah, I think it is important. Let's put it in very explicitly that judges have a right to say no to those applications to get your library records and your college records.
Professor Dinh, there is a consistent theme of reduced judicial oversight of the investigative process in the Patriot Act. Warrants are often no longer necessary or more easily obtained. As in all democratic societies, we rely on a system of checks and balances to check the power of the government. Is speeding up the investigative process worth the reduction of judicial oversight?
Let me be very clear. Your emails are not private if you engage in criminal activity or have evidence relating to a crime. Other than that, your emails are private, because your emails are the content of your communication, just as you talk on a phone. The pre-existing law, Title III of the 1968 Omnibus Crime Act, gave government the authority to tap your phone after they get a warrant in order from the court in order to tap your phone. That's what we do all the time. You see this in Law and Order and all the other places. What the USA Patriot Act did was extend the same authority to the digital world, make clear that emails are also subject to such intercept if authorized by a court when it deals with content. That is the substance of your communication. It safeguards the exact same level of judicial supervision and authorization that pre-existed. Congressman Frank pointed out very, very well that that's all fine and good in the criminal context, but what you saw was the movement of a whole lot of investigation in terrorism into the realm of the Foreign Intelligence Surveillance Act of 1976, which is an act that was designed to operate in secrets because we are dealing with spies and terrorists. But even there, Congress in 1976 and in 2001 did not take away the very important separation of powers and checks and balances safeguard of judicial oversight, but rather ensure that there is judicial oversight and supervision and authorization of these governmental activities, even when done in a top secret or confidential manner. As a matter of fact, one provision of the USA Patriot Act increased the number of judges required for the task from 7 to 11, anticipating very well that as we engage in the most massive national security investigation in the history of our nation, more judges, federal judges, Article III judges, just like anybody else, just like any other judge. Indeed, they sit by day as the ordinary judges and at times meet in their part-time capacity in order to supervise these types of investigation. I do acknowledge that we are a government and a democracy that operate in the interceptic of sunshine. And so we need to be very careful about the manner in which Congress oversees and judges supervises these types of investigation. But that is not to say that there's not a need for them, and that is not to say that the constitutional checks and balances have been abrogated by the USA Patriot Act, by the 1976 Foreign Intelligence Act, or any other act of Congress.
Well, I disagree that the Patriot Act, this is factual, and we don't have a chance to get into it in great detail, but people can pursue this. I disagree that there was no diminution of judicial supervision. First of all, Professor Dinh acknowledges a lot of it's been moved to secrecy. Well, you get away with a lot more in secret than you do in public, and that alone is a reason to expect abuse. But there are also cases where the discretion of the judge has been diminished, and where some of these things that you used to have a chance to contest because they're secret now are done ex parte in legal language. That is, the government gets to present its evidence and nobody can rebut it, or they tell you, I'm sorry, we can't tell you what we said because it's too secret. And I have to say this. Many of the defenders of the Patriot Act, and part of the rationale for the Patriot Act, go back and read the debates. What they were saying was there's too much judicial interference. They argued that. I don't think the advocates of the Patriot Act can logically say that one of the reasons we needed it was to diminish judicial interference and then deny that we've diminished the role of the judiciary. And I would just say this, if what Professor Dinh is saying is that when we renew, and by the way, only some of the sections are up for renewal, but because some of the sections are up for renewal, they're all up for renewal. Because the important principle of legislating is the ankle bone is connected to the shoulder bone. If they got to pass something, then we can make amendments and other things. But I would say this, if in fact what you're saying, Professor, is that you would agree, I'll work with you to make sure that when we renew the Patriot Act, there is no diminution of judicial discretion and authority to say no. Okay, I believe the Patriot Act had some. You say I'm wrong, good. Let's, as you said the other thing, let's make it explicit. And if what we're saying is that when we renew the Patriot Act, we will fully restore whatever judicial discretion to say no to requests for this kind of information existed before, then I'd be satisfied and I'll acknowledge, well, maybe I misinterpreted what people were looking for.
Of course, the devil is in the details. I think there is areas where the USA Patriot Act rightfully took judges out of the process. And let me explain one instance. Before the USA Patriot Act, when you're engaging in a multi-district investigation, you would have to go into each district in order to get a different subpoena, in order to get a different court order, despite the fact you already had one from the initial district authorized by a federal judge. I have never, ever seen the second subpoena be denied to a judge, to the second investigator. Why? Because another federal judge had already approved it without any change in circumstances. It's a matter of rubber stamp and shoe leather costs in going to the different 50 districts. When in a fast-moving terrorist investigation, Congress authorized nationwide search warrants so that one judge gets the power in order to approve the subpoena, and it's good throughout the country. I think you save a lot of shoe leather costs, you save a lot of good evidence, you save lives by investigating more quickly, while at the same time not diminishing any civil liberty or privacy costs, because the additional other 49 repetitive subpoenas going to the judge are simply make work.
Thank you. Congressman Frank, the government has been given increased ability to detain immigrants and deny foreign nationals entrance. Isn't it wise to put our objectives of encouraging immigration and having an open society on hold during a time when our biggest threat comes from international terrorism?
No. First of all, I do want to say I do not think that the requirement that doing away with the requirement for multiple search warrants is the only example of a diminution of the role of judges. And I will repeat, if what Professor Dinh is saying is that we will restore the power of judges, including the power to say no, the power to simply sit there and have an FBI agent tell you, I just did this, or I'm going to do it, and now you know it, and they can't tell anybody, and it's going to be a secret, that does not reassure me very much. So, but if we're talking about restoring the power of the judges to say no, and to be public, and the rule ought to be public in most cases, then I think we're okay. Although I realize those are two separate issues. With regard to immigration, one of the worst things that's happened has been the Republican assault on the principle of immigration. By the way, terrorism did lead, before the 2001 issue, to a Republican restriction on immigration. In 1995 and 1996, the Republicans passed very, very unfortunate legislation dealing with immigration, allowing for the retroactive deportation of legal permanent residents for minor disagreements, cutting off food stamps for residents who were legal permanent residents, but also being much more restrictive. And you know the act of terrorism that led to that, by the way? It was the bombing of Oklahoma City by 2 American guys. But people at the time get so panicked, and that did lead to this. Then in 2001, they did more of this. Let me give you some examples. Because if you're not an American citizen, you have even fewer rights, obviously. No, that's true. You don't have the same rights if you're not an American citizen, but we've gone too far. One of the worst things about the Patriot Act version that passed, as opposed to the one that I supported, was to change in some regards the burden of proof. If you as a citizen, as a resident, not a citizen, if you give money to an organization that when you gave it to them was not on anybody's list of terrorist supporting organizations, and it later gets added to that list, you could be at risk. You could be at risk of deportation or of other restrictions. And the burden of proof, to a great extent, is on you to show that you didn't know there was anything, that you didn't know this at the time, rather than on the government to show this. And I think the other point we'd make is this. There are millions of immigrants who are in this country illegally. Most of them never blew up anybody. They're here to get jobs. We have a problem with immigration that we have to deal with. I would like to see more legal immigration and less illegal immigration. Nobody has yet come up with a way to really restrict illegal immigration in a free society like ours, but we keep trying. But that's separate from the terrorism issue. And the notion that you should have a general restriction on immigration because of terrorism is terribly wrong. By the way, the administration has just admitted that. One of the worst things they were doing was making it very hard for foreign students to come to America. We were hurting our universities. We were hurting our universities financially. We were hurting America because no matter how bad people think America is, they come here, it's better than they thought it was, and they go back home and we're better off. And we had this terribly restrictive and abusive policy, which has now been fortunately changed over. So no, I think acting against immigration in general because of those murderers of 2001 is not only wrong as a moral matter, but doesn't help our safety.
I think on this question, we will have much more agreement, both between myself and Congressman Frank and the administration, between the administration and the congressman, than one would normally think of in this debate. So I'll just focus on the background and the specifics, because that's where the details matter. I completely agree that every single time that we as a country faces a threat, we as insiders tend to look to the outsiders, even when such looking is illogical, as in the case of the 1986 Oklahoma bombing and the passage of IDEPA in response. It's a natural, nativist, humanistic tendency that we always have to fight against if we are to remain true to our history as an immigrant, as a nation of immigrants, to reflect our liberality of spirit and generosity of tradition. I do think, however, that Congress has traditionally played this Potomac two-step game. With every single threat or perceived threat, they pass more restrictive immigration laws, but then not giving the authority or the resources necessary to enforce those laws, so that we don't have to pay the full policy cost of the restrictions. What we saw in office prior to 9/11 was a policy, an immigration policy in disequilibrium, where there are very, very high restrictive laws on the books, no ability or resources to enforce them. If we are going to return the rule of law to this nation, we have to bring that policy up to equilibrium. What was a matter of good policy prior to 9/11 was a matter of national security. After 9/11, Muhammad Atta came in here and abused the student visa, leading a number of very prominent Democratic and well-meaning Democratic senators to call for, at the time, a moratorium on student visas. We went there, we said, give us another chance. We will institute an accelerated plan in order to prevent and stop the abuse of such student visas. That's part of the policy-making process to bring us back into equilibrium so that we can enforce the laws that are on the books. Once we enforce the laws on the books, you have to recognize, consistent with the first point that I make regarding the disequilibrium, that those laws are too restrictive to reflect the liberality of tradition and generosity of spirit that define our nation as a nation of immigrants. That's why I'm so heartened that the President has come out and called for a revision of our immigration policy, especially as it relates to the transborder immigration with Mexico. It remains to be seen whether Congress responds to that challenge in order to make sense of and find a solution to those who would come here in order to seek economic benefits. But I think that we have to relax our laws of immigration, even as we bring those laws into full or at least rational enforcement.
Well, Professor Din's being very kind to Senator Feinstein. He quoted her when he agreed with her, but he didn't quote her. She's the one who called for that moratorium on visas, which was a dumb idea. But unfortunately, the administration, while they didn't do the moratorium, did crack down. They did crack down, and it took a lot of fighting to get them to change. The other thing I would say is, and I agree with much of this, as far as what Congress is going to do, first of all, the President hasn't sent in a bill yet. There's been a lot of talk, but no legislation. When he does send something in, if he does, it will get very strong Democratic support, but it will be killed by the Republicans who run Congress, who are against him on this. But what he did say he gave his approval to was a bill we just passed in the House over my objection, which greatly tightens up the asylum rules. Now, asylum is a very important part of America's tradition. A large number of the people who are seeking asylum here are victims of religious persecution. Every religious organization in America, including the Catholic bishops, asked us not to pass that law, but on a very partisan vote, the House passed it. So we still have this problem of this knee-jerk response, and we punish immigrants in general for terrorism in a way that does not help us fight terrorism.
Okay, the next question is addressed to Professor Din. Civil rights advocacy groups have expressed concern that portions of the act relating to domestic terrorism could well be used against political groups, that Martin Luther King's could be lumped with Zakaria Moussawi's. Have we created a climate which discourages civil unrest and which, founded or not, fosters fear of the government?
I certainly hope not, because I think that I return back to Senator Feinstein's earlier statement and Congressman Frank's acknowledgement that while there is need for vigilance, that the abuses and the real abuses that have defined our history in the past, or so often define our public rhetoric in the present, has not materialized, and I am thankful for that. I'm cautiously optimistic that it will continue in the future. With respect to the question of political advocacy, let me be very clear. It was foremost on our minds in the administration, and certainly foremost in Congress's mind. What we found after 9/11 is that there was no definition of and no punishment for acts of terrorism that happened within the jurisdictional territory of the United States. what we call domestic terrorism, there were plenty of provisions prohibiting and punishing international terrorism, those that occur outside the United States. We woke up from that innocence very quickly with 9/11. And so when we drafted and extended the punishment for terrorism that happened within the territorial jurisdiction of the United States, we have to adopt a definition. The extant definition before of international terrorism, I think it was 18 U.S.C. 2331, that said that violent acts or acts injurious to human life that are criminal and that are designed in order to coerce a population or affect government policy is terrorism. When you hear the word violent acts, you start thinking of political speech that sometimes go awry or that touches on violent protests. And so when Congress adopted the definition for acts that would occur within the United States, it specifically removed those words, violent acts, in order to remove any ambiguity that may touch upon the letter or the spirit of the First Amendment. So the definition is simply acts injurious to human life that are criminal, that is intended to affect government policy or coerce a government or a human population is the definition of terrorism. I think that is why I do not share the same fear that civil rights or civil liberties advocates have expressed. And this view, by the way, is shared by none other than Anthony Romero, who is the executive director of the ACLU, who, when asked in order to adopt a definition of terrorism in order to comply with some grant restrictions, he advocated Section 802's definition of terrorism because it was specifically circumscribed in order to meet the needs but not expand beyond that need in order to chill First Amendment or political activities.
Well, but that's an incomplete history of Mr. Romero and the ACLU, as you know, because when he was, and let me just, to begin, as I said and volunteered, I am very proud of the country. There has not been the kind of interference with free speech and free expression on the part of government that we've seen in virtually every other crisis. We have had much less problem here than we did under the Korean War and World War II and World War I, and I think people would have expected, since the homeland was attacked, it might have gotten worse. So I do. There have been problems. There have been more problems with private repression of free speech. And let me just say, I don't mean to get involved too much, and politicians aren't supposed to go looking for trouble in their districts. But while I think Churchill is a nut, I do not think you should have the nut that Winston, the guy who was going to talk here, and he talks nonsense, vile nonsense. I do not think you should have what's called the heckler's veto. The fact that some people are going to object to someone speaking is not ever to be a reason for not letting the person speak. That, I think, is a fundamental violation of civil liberties. But the government has not been repressive in that sense. But there is a chilling effect, and here I disagree with this interpretation of the ACLU. Yes, the executive director of the ACLU agreed to sign a requirement that said they would get grants as long as they didn't give out anything to anybody who might be on certain terrorist lists, etc. And he got yelled at by his board for doing it. He didn't tell them he was doing it. He then tried to say, oh, but here's what it really means. But he was giving an interpretation that nobody really believed, and he had to back away from that, and his board objected to that. And here is the problem, that there has not been a pattern of repression. We have got a great deal of free speech, and I'm pleased with that. But in the Patriot Act and elsewhere, there is this problem. I mentioned it before. If you were to contribute, particularly if you're a non-citizen, a legal permanent resident, to an organization later found to be terrorist, there is a guilt by association or guilt by affiliation that is problematic. There is this, you better be careful who you give to and what you do. And I think that goes too far. Yes, if people are knowingly giving money to help murderers, that's a problem. But I believe that the way the law is written, and it has in fact been enforced, and this is one area where there has been some enforcement problem, there have been some chilling effects, and some people, it's worse if you're not a citizen. And it is true that if you're a citizen, you have more rights if you're not a citizen. And I'm not for letting legal permanent residents vote, but neither do I want them to be in this country in a way in which they do not feel free to speak out. So I think there is this danger. And I want to, one of the things I want to amend in the law is to make it very clear that you are very unlikely to get in trouble because you gave to an organization that turned out to have more terrorist connections than you knew, and I don't think you ought to be penalized in those cases.
I think we're actually quite close on agreement as a matter of semantic. I agree that if you give money with the knowledge and intent that that money would go to contribute to terrorism, then I think you should be punished for that, regardless whether or not that money is laundered through a charity or given to a bagman. Because you are as complicit as the trigger puller or the suicide bomber in the blood that is on your hands, that your money contributes to. At the same time, you also have to recognize that money is fungible. And so when the money is given to an organization that engages in terrorist activity, you simply cannot claim that what you really wanted was to support its humanitarian efforts, whatever they may be, because that money can be easily diverted and used for terrorism. In any event, it can be substituted for money earmarked for guns and bombs. And so it is a matter of the fine print. That is why I think it's a matter of drafting and details.
The next question goes to Congressman Frank. Not associated with the Patriot Act, but still controversial, is the issue of preventive detention. In the Detention of Enemy Combatants Act, a bill introduced to Congress by, among others, Congressman Frank, the President is given the authority to detain U.S. citizens as enemy combatants. What is the rationale for holding combatants without access to traditional due process? Furthermore, if you believe it is sometimes lawful and prudent to indefinitely detain citizens, is there some principle that allows this detention but would disallow torture as a means of achieving our goals in the fight against terrorism? If so, could you please articulate the principle that clearly distinguishes preventive detention from torture?
Yeah, I got to say, most of the questions are pretty good. That one, not so hot. And I'll explain to you. Well, you say, what's the law? It is a bill that I co-sponsored, although I think it should have been changed some, which says the President is authorized to detain people. And you say, well, what's the principle that says, why doesn't that lead him to be able to torture? Because the bill says he can detain people, and it doesn't say he can torture people. And that's the principle. It is, and there's an important issue here. That bill I no longer support. It won't be reintroduced. It predated the Supreme Court decision in the case of Hamdi and Padilla. Here's the deal. The President of the United States announced early in this whole process of dealing with September 11th that he had the right, as I said, to lock up anybody, anywhere, anytime, any place, and he can lock you up if you were an American citizen on his say-so, and no court, nobody, nowhere could make him justify it. Nobody could ever let you out and keep you there for the rest of your life, as long as there were terrorists in the world. Now, I thought that's pretty terrible. And one of my colleagues drafted a bill that tried to put some limits on that. The bill you were talking about was introduced in a context in which the President was claiming to be able to do all that was in that bill and more without any authorization. And the bill didn't just say it could be done without any judicial requirements. It did call for some due process. I signed it saying at the time that it wasn't enough, but I wanted to at least get the process going. I did not think, frankly, in the atmosphere in which we were, that Congress would have the guts to do the right thing. And I will just say, Professor Dinh talked about how the Senate passed the bill 98-1, and he said that was a sign of how proud they were that it was a Senate bill, yeah, and how worried they were that they were going to get beat if they didn't vote for it because this was this kind of panicky atmosphere. I do not think on a secret ballot that would have been 98-1, although unlike the FBI, we're not allowed to do these things under secret ballots. But that bill was meant to be a check on the President's assertion that he could do that without any approval. It didn't go far enough, but it was at least an assertion that there were some limits. Then the Supreme Court decided in the Hamdi case that the President was wrong and that he could not do that and that there had to be some form of judicial review. Unfortunately, the administration is resisting the logic of that and is still fighting for its right not to put people up there, not to give people their rights. So the answer is I do not think that the President should be able to do this without authorization. The very fact that we filed a bill to do that was meant to be a counter to the President's assertion that he could do it on his own because it did set some procedures for it. The court, as I said, by 8-1, including Scalia and Rehnquist, said to the President, no, you cannot do that. You cannot lock up American citizens, and they do have a right to go to court. And in the case of the one guy, when the administration had to go to court to prove it, they said, okay, bye, see ya, because they had nothing apparently they could prove. And he left. He walked. They've unfortunately made the same assertion, and it shouldn't just be American citizens we care about. They made this determination
Time, Congressman.
with regard to non-American citizens, and I think what we're doing in Guantanamo, again, the assertion that we have the right to grab people and they have no recourse before anybody and they can be held indefinitely for the rest of their lives as long as terrorism exists in the world is a terrible doctrine. Fortunately, the courts in both cases have tried to put some limits on it.
After I left office in 2003 and after Mike Chertoff left office to become a judge on the Third Circuit Court of Appeals, both of us had the opportunity to appear at the Third Circuit Judicial Conference, and we surprised how much we agree on one issue, that while both of us recognize the strong presidential authority to detain enemy combatants in a time of war, we thought that the courts would more likely defer to such detention if there were a process given to such detainees to challenge the facts of their detention and legality of their continued incarceration. The Supreme Court, as Congressman Frank has noted, has agreed with that analysis in the Yasser Hamdi case and ordered the United States government to give some sort of elementary process to the determination as to the person, whether the person is properly classified as an unlawful enemy combatant. I'm heartened to see that the administration has complied with these procedures and extended it in many ways to areas where they did not need to, that is to non-U.S. citizens being held outside the territory of the United States, specifically Guantanamo Bay. They have voluntarily adopted procedures to give some sort of preliminary process to determine the enemy combatant status of the non-citizens being held on non-U.S. soil in Guantanamo Bay. I think it follows that if those procedures were adequate in order to protect the rights of U.S. citizens being held in U.S. soil, that they are ample to protect whatever rights non-U.S. citizens have outside of U.S. soil. That said, this matter is being litigated, indeed, by a very capable colleague of mine, Neil Katyal, and the D.C. Circuit will hear the case and will resolve it. If not, then the Supreme Court will resolve it. So I trust that this is an area where I am so heartened that the judiciary has weighed in to help the executive, because in many ways our nation is navigating in uncharted waters, and I do join many others in calling for the third branch of government to add its wisdom to this area, however that wisdom may turn out.
We differ here factually. I have to say, when you say you're glad the judiciary is helping the president didn't consider it to be help. He yelled like hell. He opposed it every step of the way. And I do disagree also that what the administration is doing with regard to the people we were holding at Guantanamo is somehow voluntary. They were ordered to do something by the court. They are, I think, trying to do less than the court ordered. There was nothing voluntary. The administration's position was that they could do whatever they want. And by the way, one of the most intellectually dishonest things, I don't want my government being intellectually dishonest. You're right, Guantanamo is not technically American soil. But the first Cuban soldier that comes here is going to get his ass shot off. The fact is that America controls Guantanamo, and here's what they said. They said, if we brought these people who were combatants, and many of them are very nasty people, but you know, we make mistakes. The fog of war, they scoop people, and they scooped people in Afghanistan, and there was no way for a while for them to prove that it was a mistake or even try to assert it. The courts finally said they had to do this. There was nothing voluntary about it, and what they have said was, well, you know what, if they were in America, they'd have rights. But they're in a foreign territory, and we don't exercise control there. Of course we do. It's Guantanamo. We run it. So here I think you have put much too nice a face on the administration. I agree with you, but I don't agree with the administration, and neither do you.
I stand corrected. The treaty with Cuba over Guantanamo Bay gives exclusive jurisdiction and control over the United States government. Unfortunately, the Supreme Court decision did not rely upon that particular provision, but seems to suggest much more broadly. I guess the most practical way I can put this issue.
But the Supreme Court decision was over the government's objection. They did
no question.
They didn't volunteer any procedure in Guantanamo. They were forced to.
No question. But the rights of the Guantanamo Bay detainees, unlike the rights of Hamdi, have not been adjudicated by the Supreme Court. No. All they ask for is a right to present those arguments in court. So this next round that we will see what rights.
And the administration is opposing even that.
What the best way I can explain the current disconnect is in personal terms. I was involved in the litigation for Haitian refugees in the last decade. And if you recall, Haitian refugees were held in the exact same places that the detainees are being held right now. At the time, the courts, both the 11th Circuit, 2nd Circuit, and the Supreme Court, said that they have no rights. It troubles me and I disagree with that decision, that we as a nation and we as a Supreme Court has said that people coming here seeking freedom have fewer rights than those who were brought here in order to defeat our freedoms.
Yes, if they're Haitians, that they don't have any rights. If they're Cubans, they get all the rights in the world. It's a big distinction. If you set out from Haiti and Cuba at the same time, and you get here from Cuba, you got everything you want, and if you get here from Haiti, you get locked up.
Professor Dinh, due to provisions in the Patriot Act, the FBI is given increased freedom in search and seizure of U.S. citizens. Does the FBI need this increased reach into the life of ordinary Americans to fight domestic and international terrorism? And can the FBI be trusted with these new powers?
I come from a political tradition that can be very, very well summarized. Trust but verify. I think that is the hallmark of our American traditions. Sure, after 9/11, we had this incredible sense of national unity and trust. But at the same time, I completely agree with Congressman Frank that with power comes the need for accountability. We needed that sense of national unity and resolve in order to stand as one in the common fight against terror. But we, in order to remain as one, the people devoted to liberty, need safeguards in order to verify that those authorities are not misused and abused. I do not think that the USA Patriot Act fundamentally realigned the relationship between law enforcement and the privacy and liberty of law-abiding citizens. I do think that the USA Patriot Act gave law enforcement authorities with the proper evidence, with the proper level of judicial authorization and supervision to act more aggressively and more effectively against those which it has evidence who has engaged in terrorist and criminal conspiracies. I think that that is what we need as a nation after 9/11, but Congress is very restrained and actually put in safeguards to prevent that those powers would not be misused and abused to violate the rights and civil liberties of law-abiding citizens. Indeed, several provisions of the USA Patriot Act, including Section 223, which Congressman Frank has exclusive credit for, and other provisions required not only civil liability, but established procedures to report violations of civil rights attendant to the so-called war against terror. And I think part of those procedures goes to credit for the diminution or not the lack of egregious civil rights violations that we have seen in the current era.
Now, I don't want Professor Dinh to get in trouble when he said that he belongs to a political tradition that says trust but verify. That was, of course, the motto of Gorbachev when he was still running the Soviet Union. So be careful.
No, that was Reagan to Gorbachev.
No, Reagan borrowed it from Gorbachev. Gorbachev said it, and Reagan was impressed with it and kept repeating it. But he learned it from Gorbachev. We differ not on the goal as you describe it, but on the reality. Again, I urge people. It's hard to go nitpick the law here in this brief time that we have, although it may not seem that brief when you're sitting there. But go back and read the debates in Congress. And one of the arguments for the Patriot Act was the judges are getting in our way. One of the arguments for the Patriot Act was we had to reduce the interference of the judges. And you say, well, it didn't fundamentally realign. Well, I don't know what fundamental means, but I'd say this. If we have agreement that there should be full judicial rights to say no to law enforcement before they act, except in very, very exigent circumstances, and full judicial power, even full judicial power, to review what the law enforcement has done after the fact, then we don't have a disagreement. I don't think the law quite gets there. It's not as bad as it was when John Ashcroft sent it in. We did put some safeguards in. And let me just say that one section that you very generously mentioned, 223, it's the J. Edgar Hoover, Martin Luther King section I put in. J. Edgar Hoover was a terrible racist, and he hated Martin Luther King and thought he was a crook and a communist, and he wanted to prove that. And Martin Luther King was not either a crook or a communist. What Hoover did was to wiretap Martin Luther King and find out things in his personal life that were embarrassing to him, and then released those to the press and to politicians in an effort to discredit Martin Luther King, used FBI files to do this. People said, well, hey, it's King's fault. You know, you had done these embarrassing things. My answer is, if you get to be 30 years old and there's nothing in your life that would be embarrassing if it got revealed, you have my sympathy. But the point is that we did try to take care of that. We made it easy for you to sue the federal government if any information garnered about you in the course of a surveillance is released. You can sue the federal government much more easily without a jury, and you get some automatic damages. I appreciate the administration supporting that as we put that in. I'd like to toughen it up a little bit. But I just have a fundamental disagreement. Factually, I do believe that what the Patriot Act did, among other things, was to diminish the ability of the independent judiciary, both before and after the fact, to monitor law enforcement. I think that is unfortunate. I did support the increased law enforcement powers. And when we come back at it, I'm not going to try and diminish the law enforcement powers, but maybe you say it's a matter of drafting. If we can get agreement that there should be full judicial power to say no before the fact, and if they don't show probable cause, and to review this after the fact, then I wouldn't have a problem. But I don't think the law is yet there.
If you have a reasonable expectation of privacy to a particular communication, paper, or activity that you engage in, because you do it through a telephone line or you do it at home or the like, the Constitution prohibits the government from invading that expectation of privacy except upon probable cause of a commission of a crime and except upon approval by a federal judge. Nothing the USA Patriot Act did or could do in order to offend that constitutional principle. If, correspondingly, however, you do not have a reasonable expectation of privacy because you reveal information to a third person or you do it in public or otherwise have ceded away your privacy because it is a public act, then there is, by definition, no reasonable expectation of privacy, and the government can have much easier access to such information. It doesn't mean that the judge is completely out of it. There has to be some sort of judicial approval, but not the same level of constitutional probable cause that is required by our Fourth Amendment.
This is the last question. Congressman Frank, with portions of the Act coming up for reauthorization within this year, it would seem a good time to analyze its successes and failures. When the Act comes up again, what should be removed and what should be preserved or even added?
Well, what should be removed is what Professor Dinh just acknowledged is there. Remember, he said you have two levels of privacy. And he said, if you tell a third person or if you do it in public, in other words, if you are a Trappist monk, you're in pretty good shape. But once you start talking to people, then you're not in such good shape. Once you go to college and take an exam, or once you go to a library and take out a book, your privacy gets somewhat diminished. And I think that's then this does become definitional. And I want you to have, the notion, there was this legal notion, well, you've waived your privacy. Well, there are people waiving their privacy under that definition who have no idea they are waiving their privacy. They don't intend to be waiving their privacy. They are telling people things that they want to keep private, and I think that's part of the problem. And I think that this standard, and yes, as you've acknowledged, in those cases the role of the judge is diminished. You say it hasn't been wiped out altogether. I believe in some cases the judge is merely the passive recipient of notification from the FBI in secret that they have done this, or other agencies. So I would say the most I want to do is to make sure that they have to do probable cause when they are going to try and get this information from you. I think, yes, they should be able to go into the Internet. Yes, they should be able to go to mobile phones. But I do not think that because we say, well, but you didn't understand this was an email, you didn't have an expectation of privacy. People should be aware of this, but I think people should still be allowed to treat their email as private. So the fundamental change I would make would be that. Secondly, to make sure that you have, as I said, full judicial supervision before and after the fact. And you say the motto is trust but verify. I have to say this, with regard to the FBI, there have been too many mistakes. I'm no longer quite so trusting. I'm not distrusting, but I'm neutral. We have had too many patterns of mistakes and abuses, and I think we have to make sure that everything is checked beforehand. Secondly, to go back to what we said before, part of the problem is what's not in the Patriot Act. The President is litigating against this notion that he has to give people in Guantanamo a chance to prove. Again, you know what they're being asked to be, what we're asking that they do? Prove that they just happen to be wandering around and they got picked up. Look, 20-year-old Americans, brave, tough Americans who were sent into those difficult situations, who don't speak the language can't always tell the difference between a terrorist and some goat herder. You're under fire. You're in a difficult situation. That's not the fault of these kids, but it's the fault of a system that does not give us a way in which we can check their mistakes. And as long as the administration is insisting on their right not to have to prove that to anybody or even demonstrate it, then that's the other thing I want in the Patriot Act. I would like in there some restraints on this really outrageous power that George Bush has claimed and still claims to lock up a whole lot of people without ever having to justify it to anybody or give them a chance. Now, the courts have pushed him back with regard to Americans, but he's still fighting in other areas.
As I said before, I think counterterrorism and governance is not a static process, but a dynamic one. And this conversation and the national conversation we have with respect to the USA Patriot Act gives us the opportunity to respond to the need of counterterrorism. I think there are obvious, what I call no-brainers out there that I think everybody would agree needs to, the same authorities would be should be extended to counterterrorism. For example, we have greater authority for pretrial detention of a person accused of drug crimes or healthcare fraud or other violent crimes than we do for terrorism. I think whatever is good for drug crimes should be good for terrorism. It may well give us an occasion to ask whether or not we want these powers for drug crimes and other nonviolent crimes like healthcare fraud. But at least let's bring our laws and our policies into parity so that we don't have disproportionate authority in areas other than terrorism. I think that the other types of fixes are fairly straightforward. The Richard Reed, the shoe bomber, for example, who was tried right here in Boston. One charge was dismissed because the judge found that the law prohibiting the use of a bomb against a mass transportation system did not include an airliner. Include a whole lot of other transportation system, but not the airliner. I think that's a no-brainer. I think everybody sort of agrees that that should be amended. I think on the other hand, as I said before, I think much, if not all, of the current controversy or the fears regarding the abuse of the USA Patriot Act is unfounded. But I also think that they are genuine. And I think the task of governance is not only to take care of the founded fears, but even the unfounded ones that are genuine. Because faith in the system and trust in the democratic process is very important to our system of governance. And so, to the extent that we can cross the T's, dot the I's, make clear that which should be clear in the public debate, I think I should be all for that.
Well, it's not just a matter of crossing the T's and dotting the I's. The FBI and others in law enforcement are trying very hard to interpret these ambiguities in their direction. And again, I want to stress, the assertion for the Patriot Act was in substantial part, not entirely. Part of it was we had to catch up with the new electronics, and everybody agreed with that. Part of it was we got to get these judges out of our hair, and we have to reduce their role. And I think that's unfortunate. Now, there's another issue where I don't agree with some of the critics. One of the things we ought to make clear, though, in fairness to the position I'm supposed to represent, one of the objections a number of people has is precisely that it takes powers that have existed in the foreign intelligence area and allows them to be used in more conventional domestic crimes. That does not trouble me. I have problems with drug crimes, not because of the procedures, because a lot of the drug crimes shouldn't be crimes. And we lock up, I don't think 20-year-olds ought to be locked up for what George Bush and Al Gore did when they were 20 years old. So that's a separate issue. But there is that question about how much you go beyond it.
The integrity of process to see whether or not we want these provisions not as temporary measures but as needed law enforcement tools that may well extend beyond the need in order to strictly for terrorist crimes. The simple fact of the matter is that terrorism is a crime, and terrorists do not go around committing crimes with a T-shirt saying "I'm a terrorist." And so a lot of these tools are general law enforcement tools that have very significant and specific application to terrorist crimes. That doesn't mean that they are not effective and should not be used for other types of crime. One great example is one that you're familiar with in the popular media, but may not be familiar with the intricacies of the investigation. On December 16th of last year, Bobby Jo Stinnett was murdered in her home in Missouri. and the murderer took a kitchen knife and cut out her baby, her 9-month fetus. Within 24 hours, within hours of the discovery of the crime, the USA Patriot Act was used by the FBI and the local coordinated task force in order to discover that she had been in communications in her computer with a person named Darlene Fisher. And then it was traced using USA Patriot Act authorities to a server in Kansas City, Kansas, and ultimately to an address and a person in Malvern, Kansas. Immediately, the investigation shifted to Malvern, Kansas, where they discovered that Darlene Fisher was actually Miss Lisa Montgomery, and quickly apprehended her, investigated, and recovered Victoria Jo Stinnett, thereby bringing closure to what is otherwise a very tragic human saga, but ending what would otherwise been an even more tragic national story. I think some of these examples, and examples like this, even though this is not in a terrorism context, abound in the terrorism context to show the need for law enforcement to act with dispatch where there has been crime with the appropriate level of judicial authorization and supervision, because we as a society all benefit when victims get closures, criminals get put in jail, and the innocence thereby is exonerated. And I think that Congress, when it reevaluates the tools that Congress authorized in the USA Patriot Act in 2001, will likewise reauthorize them in 2005. I will close simply by quoting a venerated contracts professor, Carl Llewellyn, who said that ideals without technique are a mess, but technique without ideals is a menace. No, it's the other way around. No, yeah, ideals without technique are a mess, but technique without ideals are a menace. I think at this time in our history, and facing the threat that we do, it behooves us to reaffirm our ideals, but also discern the techniques necessary to secure those ideals against the continuing threat of terror. Thank you very much.
Thank you. I want to begin by acknowledging Professor Dinh's comment that this is an evolving issue, and I think speaking favorably about the fact that we're going to get a chance to revise this. One of the things that people say and don't mean is, oh, I hate to say I told you so. I myself very much like saying I told you so. It's one of the few pleasures that improves with age, so I'm glad to take advantage of doing it. The administration opposed this provision for a sunset. The bill they sent us had no sunset. The bill the House committee passed had a 2-year sunset. The Senate bill had no sunset. And one of the fights we had was to get that sunset in there. And I cite that because I think what's being described by Professor Dinh, frankly, is a somewhat better version of the bill than they wanted. And I hope we will be able to keep the sunset. I'll predict to you now that the administration and some of the conservatives will want to have it go forward again without a sunset. And I think that is going to be a terrible mistake. The sunset has two roles. First of all, it allows us to make changes based on experience. Secondly, it's a leash that you keep people on because they know they have to come back in. I do want to acknowledge again, I do not object, as some of the liberals that I work with do, to using some of the powers of the Patriot Act to deal with other crimes. I do not object to that. I don't object if you find out information in a grand jury about terrorism. If you find some other serious crimes, you ought to be able to deal with that as well. But that assumes that we keep the safeguards. And I want to repeat, the fundamental flaw of the Patriot Act is that it was intended to and does, in fact, reduce constraints on law enforcement. There are two issues here. I supported and still support giving law enforcement more powers. The Wiretap Act of 1968 didn't deal with the Internet, and it didn't deal with mobile phones, and it didn't deal with a whole range of other issues. Yes, because of those mass murders and the need to be more aggressive in prevention rather than relying on deterrence, we needed to give full powers to law enforcement to go after all those devices. But it's one thing to expand the scope of their activity. It is another to remove the constraints on that activity. And that is the fundamental problem with the Patriot Act as it has been passed. It does diminish the role of the judiciary, and there are two roles. There is a somewhat limited role before the fact. That is, you have to come to the judiciary. You ought to, if they're going to invade your privacy, and privacy, in my view, including the area that where Professor Dinh said you don't really have that expectation of privacy. I don't think they should be allowed to come after you and invade your privacy without a judge saying yes. The notion, by the way, was, oh, the judiciary was going to be a problem. The shoe bomber was convicted. John Walker Lind was convicted. Zacharias Moussaoui hasn't been convicted yet, but he's been locked up and he's not walking. The notion that the American judiciary couldn't do the job and our judicial system couldn't do the job with all of its safeguards has not at all proven to be the case. So first of all, there needs to be some judicial procedure beforehand. Secondly, and this is important not just with the Patriot Act, but in Guantanamo and elsewhere, this is a very important one. Once the person's locked up, once that person has been incapacitated, and I'm prepared to support detention, preventive detention, with judicial approval, and once you are detained, a very quick right to get into court and prove that they made a mistake. So you need to have the approval of the judge before, but then a full judicial procedure after the fact. Because one of the things we know, law enforcement, like all of us, particularly people acting in stress, make mistakes. And the major flaw of the Patriot Act, and with this administration's approach, not just with the Patriot Act but elsewhere, is its resistance to having locked people up, giving them a chance to prove that this was a mistake. I cannot think of a worse policy than that, and that's one of the changes that has to be made.
Okay, we're going to open up the floor for questions for about 10 or 15 minutes now, as long as we can have the congressman and the professor's time. Robbie Grossman and Corey Ann Lonnie will be walking around. If anyone has any questions, just put your hand up and just ask, state who you're asking the question to, and please just no follow-ups so we can stay within our time limits. Oops.
Anyone have a question, please raise your hand.
That's Corey Ann.
First of all, I want to just thank you again for coming, and I think it's great that so many people showed up because, like as you kept saying, as both of you kept saying, it's important that we have this conversation, which we didn't after 9/11. But something that concerns me, which is a little broader than the Patriot Act, is there was a survey released at the beginning of the month that said about a fifth of high school, I think juniors and seniors who were surveyed, said that they thought after being shown the First Amendment and reading it, they said it was too broad. The First Amendment of the Constitution, it was too broad or too liberal or something. Basically, that it allowed too much freedom. And and a significant percentage of the people in the survey, the kids said that the government should be allowed to decide what should be published in newspapers and things like that. And so I think as we're discussing the Patriot Act, I'm wondering if you two gentlemen worry that we're sort of losing I don't know if it's our confidence in our civil liberties or just our stomach for them, but I was just curious if you had any.
No, let me answer that. First place, those surveys are done regularly. I mean, in fact, free speech and free press are never all that popular personally. Look, the people who passed the First Amendment were the ones who passed the Sedition Act, which is one of the worst abuses of free press that we ever had. In fact, I think, and this is something I think we agree on, if you look at American history, there have been very few examples. I have criticisms of the way this thing has worked, and I think there's been some chilling effect with regard to Muslims and Muslim organizations, and people are worried maybe they did terrorism, I didn't know about it. But as a fact, there have been virtually no cases where government bodies have repressed free speech since 2001. That's a very pleasant place. There were one or two cases in state universities where there was a problem. But if you compare this, as I said, to the Vietnam era, to the McCarthy era, to World War II, to World War I, go back to Abraham Lincoln and the suppression of habeas corpus, we really have come through much better than I think people would have thought. So no, I understand the trend you're talking about. There is a saving grace, which is there are high school kids, so they won't vote, so don't worry about it. But I do not think there has been any deterioration in that historically.
Let me just say this: as a refugee from totalitarian Vietnam into a country that has so much freedom, it just flabbergasts me how much we as Americans take our freedom for granted. That's in many part a source of confidence. That we can think about and take for granted that our freedom are given so freely because they are not infringed. When they are infringed is when we get mad as hell. We're not going to take it anymore. But at the same time, it also underscores the need for lack of a better word, better civic education, better appreciation of the world that we live in and how fragile this world and this country and our experiment is.
And let me just add, there's a technical factor here. With the internet, blogging, etc., Americans are now freer to talk to each other in fairly large numbers than any people have ever been in history. And nobody is even talking about trying to restrict that excessively. I know my colleagues from time to time decide that we're going to censor things on the internet to protect 14-year-olds from thinking about sex, but probably a lot of them were never 14, but it doesn't go anywhere. And I think if you look at the actual state of the ability of Americans to communicate with each other today, it's really quite wide open and it's going to stay that way.
Any other questions?
Can you hear me? Can you hear me?
Yeah.
I'm just curious, Congressman. You said, had the vote been conducted in a private forum, that 98-1 vote or 99-1 vote would have been differently. Now, you said it pretty calmly. The thing that really intrigued me was that you said it so calmly because it kind of, you left out any responsibility for those senators to vote against something they disagree with so strongly just because in fear of losing their job. Now, isn't that in fact a little bit scary that if they disagree with an amendment so strongly or a bill so strongly that they were fearful or in a sense, they were scared to vote against it for loss of their job?
Well, it's a fair question. Let me say, first I'll explain my calm. If I were to get agitated every time one of my colleagues voted because he was politically afraid to vote the right way, my veins would be permanently throbbing. Beyond that, though, there is this dilemma, and yes, I wish. Look, it's easy for me to say I have a somewhat easier district than some. I do think my colleagues sometimes underestimate people's willingness to accept disagreement on a specific issue as long as it is sincere. Nobody really expects you to vote with them on everything, but there is this dilemma more fundamentally appropriate to a university. When people see Senator takes a controversial vote, and you disagree with his vote, and you believe that he did it because the public wanted him to, there's a tendency to say, how craven. Doesn't he stand up for what he thinks? But let's go the other way. Suppose he votes against something and you believe his district, his state supports it. Then there's a tendency to say, who is he? God? How can he abuse the right of democracy? I mean, we have this tension. Should I listen to a majority of my constituents or shouldn't I? I mean, that you really can argue it both ways. I must say, it is certainly the case if you thought something was really quite morally wrong, then you never are justified in doing this. But as a practical matter, as long as you have elections, people are going to take this into account. Remember, 2001, this was an unusually emotional situation. One of my disagreements with John Ashcroft, he wanted us to vote right away. It was slowed down, but it was still in that very emotional situation. So the answer is, as long as people run for office, you're going to have that factor. You wanted to say something else?
I was just curious, you're saying people vote for, people are voting based on how the district is voting or making decisions against it.
Right.
But isn't the first priority of a senator or a congressman to vote in the best interest of the country as a whole? Thereby, should they have voted against the Patriot Act?
Well, yes and no. I think that's my own view is I run every 2 years, and I listen to people because I want to know what they think and how it's affecting them and what their views are. And then I vote the way I think is right, and every 2 years they get a shot at me, and if they don't like it, I go. On the other hand, there are people who argue that that's wrong. I mean, look, during the Vietnam War, if I'd been to college campus as a member of Congress during the Vietnam War, I would have heard people saying to me, how dare those members of Congress vote for a war when they know the public is against it? And if I said, well, they firmly believe that communism is a threat, etc., people would have been very angry. No, that's undemocratic. I mean, it's an unresolved philosophical dilemma, I believe. whether or not you were obligated to vote with your district or not. I mean, there was this famous quote from Edmund Burke, the British philosopher, who was a member of Parliament, and he said to the electors of Bristol, I guess Bristol County we're in, so we can borrow that. He said, "I owe you my conscience. I don't owe you my vote." And he explained to them why he wasn't going to vote with them. He lost the next election.
Can we try to get one more?
You got one in the back there. Oh. Yeah, we can repeat it. Go ahead.
Project.
Well, Jarrett, can you just wait so we can get on the in the system?
My question does not specifically deal with the Patriot Act, but more generally with during the last campaign. It's well known that President Bush closed off many of his campaign appearances to anyone but his political supporters or people who had donated to his campaign. Now, I understand that there's some people who think that that's legitimate because it's a private event, it's a campaign event. I'm aware of a news that came out about a month ago where President Bush attended a public event that wasn't a campaign event, where he was representing himself as the President of the United States, not the candidate of the head of the Republican Party, where he excluded members of the school board of a local town who were Democratic and anyone else that the organizers of the event were fearful that he might criticize them. While this doesn't address specifically the Patriot Act, it does address the concern that of a freedom of speech and an ability to criticize our leaders and hold them to account. Congressman, could you please address that?
Yeah, it's not technically a suppression of free speech. Well, it is in one case. I mentioned this case, a guy named Brett Beasley, who was in South Carolina, and the president was coming to South Carolina. The answer is, when it's his campaign, he has a right to do that, although I think people can criticize it as a showing of cowardice, but they do it in public. And the Secret Service has been hijacked into being a political enforcement arm. And there have been cases where people wearing the wrong T-shirt or carrying the wrong sign have been penalized, and that's outrageous. We had this case in South Carolina. The president was coming, and people were holding signs, "Welcome, Mr. President, we love you, Mr. President." And one guy was holding a sign that said, "No war for oil," which I, as a person who voted against the Iraq War, think is an inaccurate interpretation of why we went to war, but the First Amendment protects inaccuracy. And he was told by the law enforcement people he had to move. Why? Well, you're holding a sign. They're holding signs. It was clearly content-based. They told him he had to move. And in fact, what happens when the president comes in now, and we saw people talk about this at the Democratic convention as well as the Republican convention, I was opposed to it, they say we're going to have a free speech zone. And I think we should be very clear. Yes, we should have a free speech zone. It's the United States of America. That's the free speech zone. And I agree with you that this is an abuse. What happened was, by the way, that guy was then arrested. The South Carolina authorities dropped the charge. He said, "Wait a minute, I'm holding the sign, they're holding the sign. You can't arrest me just because my sign was different." But the U.S. attorney for South Carolina, under the Ashcroft Justice Department, who was a 29-year-old named Strom Thurmond Jr., one of the Strom Thurmond children you heard about before you heard about some of the others, prosecuted that guy, and I believe he was convicted. It's up on appeal now. So the answer to you is yes, I think that is abusive. It's not a repression of free speech, and I mean, it's not Patriot Act driven, but it is a problem. In fact, I have a general problem with the Secret Service, etc. I don't want the president shot, but I think we're getting a little too imperial, and I felt that way under Clinton and everyone else. The president goes somewhere in a motorcade, and they shut down cities for 2 hours before and an hour after, and that is inappropriate in a democracy. But it gets even worse when they do it with a political discrimination, and people ought to complain.
Okay, I hope it's a sign of a good event that we've run over. If there's one last question, perhaps for Professor Dinh, and then we'll have to cut it off because we really have gone over.
Don't feel obligated.
Too late. There you go.
I just have a question for Professor Dinh. It seems his logic seems somewhat disingenuous tonight, in that on the one hand he speaks about opposition to the Patriot Act as, in effect, he calls it unfounded but genuine. And I haven't heard him explain that. At the same time, he seems to be a kind of a secret admirer for those people, like Congressman Frank, who have made sure that there are those restraints on the Patriot Act and that it gets changed. So I don't quite understand what his position is He does seem to admire the opponents, in fact.
No. It's very, very straightforward. I think I admire Congressman Frank for speaking the facts candidly. And I think that the current debate over the USA Patriot Act is sorely missing in facts. A lot of it is hyperbolic fears of what the government could be doing without facts about what the government is actually doing. That's why I think that it is a lot of fears about the USA Patriot Act is unfounded. But because of the hyperbole, because of the massive information campaign that's being waged out there in the public advocacy space, you have people who have now have genuine but unfounded fears. I think that the American people should always, and especially legislatures, should always accompany the grant of governmental authority with concurrent safeguard or checks on that authority to prevent the misuse or abuse of such authority. And I don't think there's any inconsistency with the quite rational and I think very patriotic insistence on the safeguards to our liberty, while at the same time ensuring that law enforcement and national security officials have the tool that we need in order to do our job to protect and secure the liberty of America. It is only illogical if you see the world as divided into a zero-sum game between security and liberty, or law enforcement versus privacy. I think that it is. I think that it is much less logical, but far more effective as a matter of governance. If you focus on the world not as divided into black and white like that, but focus on how do you go about, quote unquote, having your cake and eat it too. What tools do you need? What is the danger that those tools will be abused? How do we safeguard against those dangers? And that way we can ensure that we have America that is both safe and free. And my basic consternation with the current national conversation is that there is a lot of heat and not a lot of light. There is a lot of passion and not enough attention. I think I hope that we have brought some light to the debate today. Congressman Frank has brought a lot of laughter also, which is always very helpful in a very charged and passionate debate like this one. And I think that Congressman Frank would join me in thanking you for participating in this debate, because through these conversations that we do govern ourselves through our elected representatives.